We will use Joint Exhibit 1001-2019, but that's a joint exhibit. It's just notice.
Well, let me ask you this. I don't think I have actually admitted all the joint exhibits. Is there a list I can just go ahead and admit them all right now?
Admit all joint exhibits?
Isn't that what we need to do?
Do you have an objection? Admitting all joint exhibits at this point?
Not at this point, Judge. No, I still want argument on that, but not right now.
So on the joint exhibits that were agreed to, you don't want to admit them at this time?
Once they're admitted, I waive all other ability to object or bring anything else to the court's attention about them. So not quite yet.
Okay.
Which one?
And then we will move to admit Joint Exhibit 1073-65 to 69.
Okay, so what did we do with 1001?
We would move to admit that as well.
Okay, so 1001, is there any objection?
No objection.
Okay, court received 1001. What's the next one?
Your Honor, we were admitting 1001-2019, one page. 1001 is several thousand pages, so we just want to admit this one page at this point.
Do you mind if I just see
Well,
this one? Yeah,
let's
we do.
be. Can we be fair to the clerk here? So we've got an exhibit. How many thousands of pages is the exhibit?
1001. That's the JHAPS record.
They're the all children's entire medical record.
And we're admitting one page.
Yeah, we don't want that. We're not saying.
At this point,
Your Honor, the concern...
I don't understand. You all agree they're joint exhibits. They're hence the name joint exhibit.
We agreed on the condition that we not waive hearsay within hearsay exceptions.
and additionally, this was a process. It was supposed to be a give and take. We went first, unfortunately, and stipulated as many things as we thought, in all probability, this court was going to let into evidence. At the point we were supposed to then start in on our stuff that we wanted in, we tried on 3 occasions to try to get stipulations. Each time it was narrow it, narrow it, narrow it. Not a single document, even those that we identified, did we ever get a stipulation on. So theirs, through our goodwill, were stipulated in, and they never reciprocated on any of ours, causing us to now have to put in by hand, I don't know how many exhibits, and waste everyone's time. That's our position. So if they're going to do that, I think it's a tactic. I believe firmly it was a tactic, and I'm not willing to allow that to go on.
Okay, well, again, we've talked about this multiple times. Ms. Crowell, I'll let you say what you've said before on this issue, and then
I don't have to repeat myself, Judge.
Okay. But can we just for the, and I know your assistants have done an incredible job at creating these 90, there's only 2 of the 5 carts of exhibits. And if we're going to have an exhibit that's many thousands of pages and then introduce one page, do you understand how difficult that is for the folks over in the clerk's office to have to try to keep up? So I understand that you all need to do what you need to do for your case, but let's also please be fair to the clerk's office who's trying to keep up with this ever-shifting, is it in, is it not in, can we agree, but it's only a couple pages out of something that's already been agreed to, but maybe it's not agreed to. It's just unclear and unfair.
Would it be possible, Judge, to mark this, use it, display it, and then give us the opportunity so the witness can comment on it, and then we will meet again. If we don't get it done before Tuesday morning, I will revisit all of the stipulations. And so that way, the clerk would simply mark this one page for identification, and then we will give it a little while, and hopefully we won't bother the clerk too much.
Mr. Whitney and I have an agreement that for this witness, for both direct and cross-examination, that joint exhibits can be displayed and publicized. So if that's what they're looking to do, I don't have an objection at this point. It doesn't solve the court's
Well,
problem.
I thought joint exhibits were agreed to and can come in, but
Right.
apparently that's not the
And
case.
we agree joint exhibits can come in. So anyhow,
So I want this resolved. I don't want to spend every single trial day having these conferences on things that you all should have resolved a month before trial. So we will admit only page 2019 in Exhibit 1001, but we're not going to do that on a going forward basis. If you're going to admit an exhibit, the exhibit's coming in. If not, it's not coming in. Okay. Now, I've only dealt with 1001-2019. What else do we agree on at this point?
I think we're down to one hearsay objection for this witness with Mr. Hall.
Well, I'm asking what's coming in right now before we deal with what you don't agree to.
All right. Additionally, 2408-1675.
I think I already admitted that one.
All right. And I think you already admitted this as well. 2510, pages 001 to 004.
2501-001 through 004.
Yes, Your Honor. And Joint Exhibit 1073, pages 65 to 69.
No objection. Again, it's a larger exhibit that we're putting in as an excerpt from.
We're fine with that entire exhibit, 1073.
Okay, I'm going to receive the entirety of 1073 at this point.
And then the last from our side, there is an objection to this exhibit, which is 2408-0082.
2408-0082.
It's an email, Your Honor, from our next witness.
You should be able to put it up at this point.
Your Honor, we made a little configuration change.
Someone was messing with this panel up here, I can tell.
Essentially, in order for the live stream to be able to display the exhibits, we wired into there. So if you leave his on, he's going to hit his switch to turn mine on, and the stream is going to pick up the exhibits, not just the audio and video.
Okay, so who is driving, who is putting up the exhibits?
To my left.
Okay. So I'm not going to...
Correct. I'm disconnected from counsel's table, and I'm connected there. And this is my published document.
Okay, so we're still using you or driving it, but it's going to come off of a feed.
Correct.
From a
I
different
have a
table.
line here, and he's just going to switch to a different channel, and I'm still going to run everything
Understood.
for us.
Okay, thank you. Okay, so I'm looking at 2408- something,
0082, Your Honor.
0082.
Your Honor, we understand. Do you want a moment to review before I...
Okay, so this is from somebody from the school board to Ms. Kowalski.
To Ms. Kowalski, yes, Your Honor. We understand the objection to be hearsay. We point out first that
Yeah.
2408-1675 was previously admitted, also from this witness to Mrs. Kowalski. We point out further with respect to the hearsay objection that this is a business record. Ms. Desert is the custodian of these records and will testify as such.
It's hearsay.
Well, it's clearly hearsay, it's just whether there's an exception for
Yeah,
it.
I don't believe that every single email sent by a public employee is automatically a business record. I think the only exception they've tried to admit it for is as a business record exception. It's just an email from a teacher to a parent.
Well, at this point, there's, if you're trying to demonstrate that it's a business record, the Israel test, I don't know if you're going to survive that test. So, I mean, you can try, but unless and until you're able to do that, it's hearsay without an exception.
Understood.
I mean, if you can prove it up, the Israel test, then you can get it in, but if not, it won't come in.
There's one other issue from the court that will tie into something.
Before you get there, the clerk wants to know on Exhibit 2696. 2696. What one was that?
Video of them taking the school,
Is the 2696 the one that we watched in front of the jury, or is that a different video?
I don't have that number. There was a 2698 video.
This is what I want. On Tuesday, you all are going to come with a sheet of paper. Any exhibit that is agreed to, I want it in a section. Any exhibit number that is not agreed to, that you want to use, is going to be in a separate section. The clerk's going to get a copy, and I'm going to get a copy, so that I can follow along and we don't have all of these issues. So 2696. What specifically is that? Someone needs to tell me what 2696 is.
I can tell you it's the video of them playing pool.
Is that the one that we played earlier in the day?
Yes. Yes, Your Honor.
Yes, Your Honor.
2698.
Because we thought that was 2698. So someone put up 2696.
This is 2696, Your Honor.
This was not.
This is a different.
2696 was not shown to.
That's correct. 2698 is the one that was shown to the jury.
Okay. So 2696 is not in at this time.
That's correct.
Correct.
Madam Clerk, anything else?
That's all.
Okay, Mr. Altenberg.
I'll be very brief, Your Honor. At least twice this morning, we've had witnesses already talking about the hospital taking custody or taking Maya. And as you know, I've told you I will be requesting special instructions on this. I don't want to resolve this now. I'm going to give you a 3-paragraph suggested special instruction that I've given to the other side as well. Realistically, I think the first 2 paragraphs are the most important to explain who took her into custody. My preference would be to try to resolve this and give this before the jury is released today, but you need to get going, so we shouldn't talk about it now.
So the plaintiff has seen this?
Yes.
Is this going to be a Mr. Elegant issue, or is this Mr.
Yes, Your
Whitney?
Honor. We were only presented it 3 minutes before Your Honor came in.
And of course, we strenuously object to this. It misstates the law, the evidence, and there's no place in the middle of the trial. And certainly there'll be a discussion at the end, but for now.
Well, I'm going to be inclined to give something relatively soon. Whether it's today, it's probably not going to be today. It might be on Tuesday. But we need to understand what is being tried. The jury needs to understand what's being tried and what is not being tried.
Yes, Judge. We have arguments, though.
You can have an argument, but what I'm saying is most likely I'm going to be giving something, so perhaps you could ask Mr. Elegant to work with Mr. Altenburn over the weekend on that particular issue so that on Tuesday morning we can either have an agreement knowing that I'm going to give something, or I'll have to make a ruling and each side can give me their version and I can read the one I go with.
Thank you, Your Honor.
I do have one last issue, Your Honor, before the witness testifies, just so we don't have to excuse the jury. The one medical record that was attempted to be admitted in is a social work note involving this next witness, Jackie Dietrich.
Wait a second, the one page of the thousands of pages that is in?
Correct, Your Honor. I'm happy to put it on the screen.
Yeah, can someone put it on the screen so I can?
It's 2019, it's 1001-2019. And if you'll zoom in, and this is my concern, and it goes with what Mr. Altenberg just said. If you note in this note, it says, social worker escorted up to Jackie Dieter from Sarasota, homebound teacher is well known to Maya. She and Diane and another teacher will be working with the patient until she's placed. Nurse asked that laptop not be left with the patient for fear of outside contacts. Teacher wants patient to Skype with her classmates. The concern we have, based especially when it went on this morning, is that the plaintiff is going to try to elicit testimony from this witness that the hospital made the decision that Maya couldn't have a laptop. The problem with this is there's an email of the same day from DCF to the hospital saying, quote, Maya is not allowed to have her laptop and phone kept there right now as there's being info being shared from the mother who has been court-ordered no contact. So, again, we have a legitimate fear that the plaintiff is going to try to get testimony from the teacher. You try to leave Maya with a laptop. The hospital said no. We have no way to rebut that without getting in extraneous emails going on the same day. These are court orders that the hospital is following with regard to laptop use. So we would just ask that, that there not be an implication if they're going to talk to her about this, that this was the hospital precluding the laptop. It's all by order of DCF. And I have the documents to show you if you want me to publish the emails.
Why isn't that? Why can't the hospital, in its case, call a witness on that particular issue?
We could, right. I mean, I guess the cross-examination, as long as I have room to do it, is you're not aware whether the refusal for the laptop was pursuant to a DCF order. It just, again, it's bleeding the issues that we saw all morning with asking witnesses, visitations and things. All of this is being controlled by the court. And we are afraid, which is why Mr. Altenberg approached you about an instruction, that the plaintiff is trying to implicate denials of visitation, denials of laptops, of personal items to hospital decisions. And like I said, we have emails of the same day. It's DCF saying she can't have the laptop.
Well, Mr. Anderson?
Well, Your Honor, the fact is that the court order itself was relatively limited. And so what we have here is the hospital writing over to DCF and asking them to send an email back to them, telling them what they asked them to do. But the order itself says nothing about depriving this child of a laptop to learn. And in fact, the testimony will be that the state, there's a separate order, and DCF allowed this teacher in, and she will so testify, to teach Maya there, and that part of this learning was a special program on that laptop. So before we get into which order, I think first we need the testimony, and then the court can determine, once you hear all of the evidence, the steps to take. And that has been our position throughout this, is that for every one of these actions that we are talking about, you will see, and we will prove, that Johns Hopkins makes a decision. They call over to DCF and say, we think this is going on. DCF, you need to write them back. DCF, like robots, writes right back to the hospital and says, don't do this. And so if you compare those and then go back to the actual order issued by the court, it has nothing to do with it. In fact, it's diametrically opposed to their own internal rules and procedures at the hospital. So they're violating their own rules and procedures, and to get around that, they're going up to DCF. But none of this is pursuant to a court order.
At the end of the day, the court order says what the court order says. And obviously I'm going to be instructing the jury that the parties were obligated to follow the court order. If it is something beyond the court order, then that's going to be fair game.
Okay. Understood.
Anything else?
Not for plaintiff.
Let's bring in the jury.
Yes, sir.